DuPont versus Light Landscape.
Ms. Danielle? You may proceed.
Good morning, Your Honors. May it please the Court, Julie Daniel for the Department of Correction, and with me is Counsel Wendy Weber. This case involves a challenge by the plaintiff, a white male, who was incarcerated in the Department of Correction and claims that his right to equal protection was violated when he was placed in the Department Disciplinary Unit pursuant to a regulation that on its face is sex neutral, however, is applied, as he claims, in a discriminatory manner. That regulation, the disciplinary regulation 103 CMR 430, provides for that the Commissioner of Correction may form a DDU, and the Commissioner of Correction has chosen to at MCI Cedar Junction.
Is there a DDU for women?
There is not.
Is there a DDU in every male facility, or simply just a few that are available for any male within the facility, within any facility?
The only male facility that contains the Department Disciplinary Unit is MCI Cedar Junction.
So there's one unit, and if someone is disciplined at Concord or some other institution and is sentenced to the DDU, they then will go to Cedar Junction.
Correct.
Right, so other people can be sentenced to DDU, not just Cedar Junction males.
Correct.
Can women be sent to Cedar Junction?
No, women cannot be housed at Cedar Junction. However, if it were necessary in...
No, wait a minute. Essentially, it's not so much whether they can be housed in a male, it's because the Commissioner has determined that men, rather than men and women, need this kind of discipline because they commit offenses on a sufficiently frequent basis as compared to women, that having this facility, which is an expensive facility, only for men is justified. Am I correct?
That's correct, Chief Justice Marshall.
So it's not as if he's saying, I've been trying to get one built at Framingham, but I haven't been given the money, or I want to build one there, or I wish I had one. He's saying, I have made a determination that men more frequently engage in certain kinds of conduct, which is a disciplinary violation, which requires that they be sent to a DDU-type facility. And I have determined that having one at MCI is sufficient for all the men in the state, correct?
That is correct.
And the statistics blow that completely apart. They show that women commit the offenses, the same kind of offenses, while in prison or incarcerated.
Based on the statistics that were supplied, it's my understanding, or is what you're saying, is that all the statistics support that the men are the more violent offenders. The men are the more violent offenders, and the only disputed fact below was in the number of assaults committed by each sex. Is that right?
That is correct, and I would say that the court below never should have even addressed the issue as to the violence of men and women within the prison system, as it should have determined in the first instance that men and women are not similarly situated. The only thing the plaintiff stated was, I am a male prisoner convicted of a felony, and female prisoners are not subject to the DDU.
Can I ask you this, though? I mean, I understand your arguments here. Let us say that the Department of Corrections did a study, determined that Hispanic males committed more violent crimes in prison than others. Therefore, a DDU was necessary, and for Hispanic males, gang-related activity, whatever their statistical basis was. So it determined that the DDU would only be used for Hispanic males, not white males, not African-American males. Would that be okay if it were sort of based on some statistical analysis?
Absolutely not, Your Honor.
Why? Why is it different?
Because race and sex are significantly different in the prison population.
Well, Johnson blows that out of the water, so let's just forget
Sure, Johnson
that.
blows that out of the water, but I'm wondering why it's different than Johnson?
Because
Stated differently, why should we not treat gender the way race is treated in Johnson?
Because Johnson stresses that separate but equal is never equal when we consider race. The prison population in and of itself must be separate and equal. If you were to say that the Johnson standard applied, we would then be in a situation of housing men and women together, which would not only may we not house, pursuant to statute, men and women in the same cell.
Yeah, but this is different. This is about punishment. The DDU, you would agree, is terrible punishment, is it not? You're locked in the cell. You don't get newspapers, no TV, no radio, as I understand it. You get 1 hour of exercise, maybe a week. There's no windows.
I would only disagree with the fact that that the DDU, the lower court compares the DDU to an isolation sanction for women. That was improper. This court in Torres found that a DDU sanction was not equivalent to an isolation sanction. The inmates in DDU are able to receive a newspaper. They're able to earn TV and radio after a set amount of good behavior.
Well, all right, but it strikes me as it's a pretty bad place. Now, here's 2002. Females, we've got about 535, just looking at one statistic, 111 assaults on inmates, females on other females. Okay, that's about 20%. Males, 9,841 assaults. That's less than 10%. So what justifies sending the males to the DDU if they assault another inmate when the females don't go and their percentage of assaults is much less?
Because looking simply at percentages misleads what the organization and ability to manage a prison. The disciplinary
But what
regulation...
if we look at types of assaults? The statistics show similar disparities, whether it's with a weapon, without a weapon, with food, without food, similar disparities, that the women are, in many cases, committing more of them than the men.
That may be true by percentages, but when you only have 300 female state prison sentenced inmates who have been convicted of a felony to serve more than 2.5 years, managing those inmates is far easier than managing an inmate population of 10,000.
Well, what do they get 30 days solitary, something like that?
There is nothing in the record that compares exactly what women who committed the same offense as...
So at least on that issue, it may have to go back for trial.
If, in fact, you have to address the issue of the standard, it must go back for an
Now,
evaluation.
this guy spent 55 months in the DDU. Now, maybe he's not a good guy, but 55 months, did he not?
Absolutely.
Ms. Danielle, may I ask you this? We are presented here with a claim of somebody who is at the disciplinary end of the spectrum. And essentially, as I understand it, your argument is that the commissioner has determined, based on statistics, and you've just said when you've got 300 women convicted of a felony, they're easier to manage, and so the commissioner has determined that a DDU unit is not necessary at the women's place of incarceration. And I recognize that, at least for the present, we have nothing to suggest that there's any constitutional requirement that men and women be housed in the same facility. You may find corrections people who will tell you that that would be better than housing distinct racial groups together, for example, but we don't yet have such a ruling. The concern, which is articulated primarily in the amicus brief, is that if the commissioner is free, because he has separate facilities, to make gender-based determinations as to what discipline is appropriate, why was he not free to make gender-based determinations as to what rehabilitation works most effectively, or what resources should be made available to people of different genders? And the two examples that they use, I assume at least two of the examples, trying to look at both sides of the gender equation, is could the commissioner deny parental visitation to men because the commissioner determines statistically, on average or whatever it is, that women are more important in the lives of children and therefore whatever it is? Or could the commissioner say, I'm not going to provide woodworking classes or science classes or engineering classes or whatever it is in Framingham? What's your answer to that?
Those type of programs, first and foremost, if you were to deny, for example, a male father a visit, would not even, unless you can really give a good basis for it,
Well,
it's not
I
even
want
going
you to really give me a good basis for why men have got, and that's what I think Justice Graney is getting at. What's the really good basis for saying, given that you've got separate institutions, that for men you've got to have this kind of disciplinary unit and not for women? I'm looking at it from his point of view.
Because the institutions are so vastly different.
But they are
MCI
vastly different because of numbers, you've told me.
Not simply because of numbers. Statutorily, MCI Cedar Junction is the only state prison in our state. There is no statute that designates a state prison for women.
Yeah, but that doesn't help
Well,
me
what
when I'm
difference
trying
does
to...
that make? Suppose a male...
I'm trying to think of it as a matter of constitutional law, of
What if a male inmate attempts to attack a guard with a shank? He goes to the DDU. A female inmate down at Framingham attempts to attack a guard with a shank. What happens to her?
It would depend.
It
Either
would depend.
if it was an extremely serious assault, which we have had one,
Let's assume the assaults were equal. The male did the same thing the female did at the two different prisons. He goes to DDU. Where does she go?
if the woman cannot be housed at Framingham, she would go out of state. Because if we had a male who committed an assault with a shank on a guard, and the guard was physically assaulted, we have had that happen once at Framingham, and that particular female inmate has been transferred out of state. Because
So you send her to a DDU, is what you're saying, in another state?
in order to manage the female population, there was no place to safely house her. And the establishment, although the commissioner could have, and if necessary in the future, would establish a DDU at Framingham, to establish a DDU for one inmate is not a realistic proposition.
Well, you're putting nonviolent males in the DDU at times, aren't you? I think the record shows that, doesn't it?
No.
No? No
No.
nonviolent male has
And if-
ever been in the DDU?
Not to my belief,
I
and
won't
if
find
we're
that in
going...
the record?
I don't believe it is in the record, and
All right.
if we're going to address that issue, the case needs to be remanded for a factual finding as to the
A
types.
male inmate assaults another inmate.
Yes,
Serious assault, injures him.
Yes.
DDU.
absolutely.
Female inmate does the same thing to another female inmate. What happens to her? Serious, same injury, broken jaw.
Most likely, the disciplinary sanction would be an isolation sanction, possibly along with a loss of privileges. It would have to be dealt with on a case-by-case basis. If those two inmates now can no longer, because there is only one female prison, be housed together, and the one female prison is designated as a medium security level 4 facility pursuant to 103 DOC 101, if there's no place else to send her, she would then, one of the two, most likely the person who committed the disciplinary offense, would have to be sent out of state to another facility.
Danielle, could I go back to my question? And I didn't write down what you said, but when I asked, when you were talking about different programs, you said there would have to be a really, really good justification for it, or a really, really good reason to deny parental benefits or whatever it is.
Something like that would not even pass a rational relationship test. So the commissioner could not deny a male a visit with a child where, with the exact same situation, a female inmate. But as a
Are
whole...
you telling me that all I have to look to is, does the commissioner have some rational basis for this?
Absolutely. Not only that,
Because you've got separate facilities?
because the disciplinary regulation addresses management of the prison. The purpose of the regulation is to manage the prison and maintain positive inmate behavior.
The problem I have with management of the prison is that's everything is management of the prison. I mean, we have cases up here on religious grounds, and the commissioner comes in perfectly appropriately and says, I've got to manage this place. I have to manage this place. And so I think the concern is if it's simply, as long as the commissioner says, in my management judgment, this is what I should do, that's a very wide door. And the question is, how do we scrutinize what the commissioner has proffered as an explanation for his decision here?
With the decision of a DDU, you don't even need to reach that, because the men and the women for this purpose are not similarly situated, where we have a level 4 female facility that houses convicted felons and awaiting action inmates and
But you're saying they're not
alcoholics.
similarly situated because they're in different buildings or different facilities. The DuPont is saying here, it seems to me, that we are similarly situated because we are human beings that are being punished differently for committing the same acts.
Or put it,
How do you reconcile?
If I can just put a gloss on that, what he's really saying is the reason why there's a DDU unit is because of gender stereotypes, and then you say, well, I've got the statistics, and they, as Justice Glaney said, take issue with this. DuPont takes issue with the statistics. So it's not simply that you've only got a level 4, this, that. It's because of a gender determination that men, not just numbers, are going to require this kind of disciplinary unit. That's the argument.
But I don't understand why there's an ignoring of the statistics that there were 22 major riots at MCIC to Junction in a certain time period, while there were none at Framingham, that there have been a number of homicides during a certain period at MCIC to Junction, and none for females, just because the number of assaults was skewed differently. All the other statistics are so heavily show that you're dealing with a very violent segment that's very violent of male prisoners, where you aren't with the female prisoners. The statistics of no homicides alone, it would seem to me, would be sufficient.
absolutely, Your Honor.
Do you want to answer Justice Fina's question, if you can remember it?
You're focusing on the fact that the sexes are kept in two different buildings, and it's the management of what goes on in a building that dictates what the standard of review should be. And you're saying it should be the lower standard of review because it's not a gender-based distinction that's being made. It's a management distinction that is being or it's a management act that is taking place in a certain building as to the population in a certain building. But the plaintiff in this case seems to be saying you've got to treat the sexes the same if they commit the same kinds of violations.
Actually,
But the
Your Honor,
statistics show that they don't commit the same types of violations.
No, but
Yeah,
that's-
but I'm
that's
talking
not
about the
just-
standard of review. You're applying, the DuPont is saying you should apply the strict scrutiny standard. You're saying, no, you don't get to that point because we're not dealing with gender. We're dealing with what goes on in a certain building. And the management decision as to what goes on in that building is not subject to strict scrutiny, but it is subject to the rational basis test.
exactly, Justice Spina.
Why?
I'm actually not completely saying one building versus another building. I'm saying that when you look at the prison, the population as a whole, there are 10,000 male inmates, 550 female, but only 300 of those 550 have been convicted of a felony, of the women have been convicted of a felony that they are serving over 2.5 years. So of that population, we also have awaiting action inmates. We have alcoholics who are civilly committed. We have House of Correction inmates. Whereas in the male prisons, there are separate facilities for each of this. So it's one facility for females and multiple facilities for males. So we don't even have to reach the point of getting to what standard is used. They're simply not similarly situated, based on statutes, regulations, and the number of inmates and the security level that they're at.
Thank you, Ms. Danielle.
Well,
Thank
let me just add one follow-up. What if you had could you maintain a prison for black inmates, a prison for Hispanic inmates, a prison for white inmates?
No, Your Honor, we could not. That would be a violation of Johnson, unless we could meet
But the claim there, which was very well supported by the record, correct, was, I've got a serious management concern.
And I
And
want
that case was
to
remanded.
segregate the races.
And that case was remanded for a factual finding as to whether or not it would pass the strict scrutiny test. With race, those men, all of the men were similarly situated, and all men, there is no way that I would argue that the men in our system of different races are not similarly situated. They are indeed similarly situated.
Would you agree, at least to this extent, that if what Justice Glaney and you, I think, have concluded is that the far harsher disciplinary treatment, okay, we're not talking about sentencing, disciplinary treatment, is based on gender stereotyping? If it is based on gender stereotyping, then you don't have to establish that the two groups are similarly situated. As I understand, the thrust of the complaint is that this form of harsh disciplinary treatment is based on gender stereotyping.
But how is that supported
Hold
when
on,
the
hold on.
statistics contradict that?
I guess I would disagree in the first instance that.
Yeah, I'm just trying to say that if it is based on gender stereotyping,
The plaintiff still has the burden to demonstrate that he and whoever he's comparing himself to are similarly situated.
Well, all we're looking at here is whether there should be a trial. That's all we're looking at. Whether summary judgment was properly granted or strike that, denied. And all these other little things we're debating can be straightened out at trial.
That's correct, Your Honor, and if in fact you find that either that they are similarly situated or there's insufficient evidence in the record to determine that the case needs to be remanded for a trial, we agree with that.
okay.
Thank you.
Thank you, Ms.
Thank you.
Mr. Chelakim?
May it please the Court, my name is Aviva Jerusham, and I represent the Appellee.
What do
Michael
you
DuPont.
say it means for men and women to be similarly situated in the prison context?
Men and women are absolutely similarly situated. I think you pointed it out most eloquently. Men and women are both prisoners in the prison system, and they're both subject to disciplinary infractions and treatments that are conferred upon them. In this particular instance, as you've observed, and I think as the briefs point out, for any infraction, and I think the Court needs to understand what those infractions are under the CMRs, women get at most 30 days in a segregation unit. And this is their punishment. This is exactly what it is.
So,
You mean if some woman killed a guard, the most she would get was 30 days? in
Well,
segregation?
obviously, she would be subject to whatever criminal prosecution.
No, aside from that, but while the criminal
That-
prosecution is pending, you mean she wouldn't be sent out of state or something?
She may be sent out of state.
Well, that's a pretty harsh penalty to someone who can't then see their children because she's in Arizona.
That is true, but in this particular instance, what we're dealing with is typically 99.9%, and I ask the Court to focus on that, essentially disciplinary infractions that are a day-to-day routine within the prison system, both men and women. Assault, anything from assaults to failure to comply with the rules and
But
regulations.
22 major riots between 1993 and 2003 in 10 years, so that's probably two major riots
Is
a
there any-
year.
is there any-
That's almost a day-to-day
Well,
situation.
Is there any evidence to suggest that housing men in the DDU stops riots?
I think that's the point. I think, and
In other words,
all,
what you're dealing with here is, what does this woman prisoner get, what does that male prisoner get, if both of them throw food at a guard when the guard is passing?
that's precisely it. That's my concern. My concern is that, first of all, the fact of 22 prison riots is essentially a red herring. I'm asking the Court
Well, it's
to...
not a red herring at all. Quite the contrary. It's probably the most dangerous situation that can be confronted by any institution, inmates and guards alike.
Absolutely. We're not questioning the
But there were no such,
responsibility.
and there were no riots during the, you haven't pointed out any such statistics to support the fact that there were riots.
What we're asking this court to do is merely affirm the standard of strict scrutiny and allow the lower court to review the evidence and make a determination as to whether or not the DDU serves a compelling governmental interest and is the least restrictive means to effectuate
and
that.
the riots would probably be relevant on that issue.
And they may be relevant, but in this...
you have to look at the case from either one of two prisms. The prism that they're looking at it from is management, and the prism you're looking at it from is punishment. For identical offenses in a male prison and a female prison, there's vastly different punishment. Correct?
That's correct.
What is your best argument for saying these two genders are housed in different facilities, always in the state?
The court has always recognized the privacy concerns of men and women.
No, I understand. Always in the state. They're housed in different facilities. And as a consequence, they are going to present different management concerns. Not because they're men and women, but just because you've got different populations. It is why a house of correction presents different management concerns than a state prison, because state prisons tend to collect the people who have done the most serious crimes, whereas when you've got a single house of incarceration, place of incarceration, you've got a whole wide variety of people who, apart from numbers, may temper the way things are conducted, may be role models, all kinds of things. And what the commissioner is saying is, look, I've got men in one, women in another, and I'm making management decisions based on my on-the-ground reality. It's got nothing to do with the fact that they're men or women. It has to do with the fact of who's in this correctional facility.
But
No, not but. What's your answer to that? Why shouldn't I go in through the prism of management? Why do I have to go in through the prism of gender?
well, it is because the classification as applied is gender, and regardless of the prison...
Ms. Danielle would say, forgive me, it's not gender, it's that I have to, let me put it this way. There's one way that we handle litigants in this court. We've got terrific sound systems, people are very deferential, people are not talking at the back of the courtroom. But if you get into a busy district court on a Tuesday morning, the first call, it's very different. And what the commissioner is saying is, I've just got a different population. I just look at that population. I've got a different population. When I get really, really bad cases, I ship them out of state because I don't have the capacity to do it here. But I'm looking at it from a management point of view. And I have determined that from a management point of view, I cannot manage the safety of MCI unless I have the full range of punishments.
And that's what Johnson dealt with. Johnson dealt with exactly that question. The Department of Corrections, California Department of Corrections, in that instant said we have serious safety and administrative concerns, exactly as the Department of Corrections is saying today. And in that particular instance, I'm sorry, Your Honor, the court said, no, in instances of racial discrimination, pernicious racial discrimination, which has been a long-standing blemish on this country, we won't permit it, regardless of whether it takes place in a prison context.
But once I'm sorry.
I'm sorry. And all we're doing is asking this court to essentially apply the same standard of strict scrutiny, which we recognize is on the same level as gender is to race in this particular Commonwealth.
But once you admit, or once you acknowledge that there can be discrimination on the basis of gender, at least in terms of separating the sexes into two different prisons, once that classification has been made, then it may very well be that the department is entitled to use the lesser standard, not the strict scrutiny standard, but the rational basis standard as to what goes on within each of the separate classifications.
I think legislatively, if you review the history, we've always recognized, and this goes back to the legislative history of the Equal Rights Amendment, we've always recognized that privacy concerns, which is why there are two separate facilities, have got to be recognized. But beyond that, and again, the legislative history of the Equal Rights Amendment has made it abundantly clear that neither lack of equality, whether it be in the disciplinary context or in the rehabilitative context, would be tolerated.
Let me ask you this. Let's assume that you are correct, that we look at it under strict scrutiny. Why do you need a trial? In other words, you concede that the commissioner is not at fault, or the legislature is not at fault, or whoever decides, where the genders are separated, for separating genders, correct?
We agree that
Okay, so
there
you're
are
not-
two separate
you're not-
facilities that are
you're not
permissible.
strictly under Johnson. Even if I apply a strict scrutiny standard, the commissioner says, I have this number of male prisoners, or put it differently, I have, for the present time, the numbers are changing over time, but for the present time, I can house all convicted and awaiting trial women, defendants, or convicted persons in one facility. And that gives rise to certain kinds of management issues. This is the way I can keep everybody safe. This is the way I can discipline everybody. When I go to the male side, simply because the numbers are larger and because of the way the system functions, and nobody's saying that there shouldn't be houses of correction and there shouldn't be, community half houses and so on and so forth. This is the way I have to do it when I've got essentially mostly people convicted of very serious crimes, and I don't have too many awaiting trial prisoners. We do have a couple, I know, at NCI, but not many. We don't have too many people who've been convicted of minor crimes, misdemeanors. We have the most serious, and in order to manage that population, I can't have the kinds of programs that I have at Framingham.
Or I need a DDU.
Well, that's what I'm saying.
Yeah.
If the commissioner has compelling evidence, again, under the standard of strict scrutiny, that it serves a compelling governmental interest and is as narrowly tailored to effectuate those means, then they have met their burden of proof under strict scrutiny.
The same kind of claim that we're talking about now was made in Johnson, more or less, except race was the issue, and it was shot down.
Well, they sent it back, correct?
Sent it back.
Well, all we're asking for this court to do
Send
is
it back.
reaffirm the standard of strict scrutiny.
Yeah, by way of sort of a factual background, how many DDU units are there, cells or whatever they are? Do you have any?
There are 124 cells, and I'd ask the court to consider, because I think the
So
court...
if they built one at Framingham or created one at Framingham, it would be fairly small.
It would be, but I want the court to understand, the 124 beds was not built as a DDU. I don't want the court to consider, have an image of, for example, an Alcatraz where they spent time and expense.
Right. They took something that existed and...
This was the segregation unit that was built in response to one of the cases which decided that the conditions in the west wing of MCI Concord were abysmal and needed to be revamped. When they were revamped in 1992, Commissioner Larry Dubois at the time believed, as part of his previous experience on the federal system, that he would like to experiment with the DDU and see if something like this would work. And literally, by the department's own initiative, decided that this was an experiment that he would like to try.
Does the record show whether nonviolent male offenders are ever...
Yes, it does. We have affidavits from individuals who have committed, who are incarcerated for nonviolent offenses, such as drug offenses.
Incarcerated in the DDU?
Incarcerated in the DDU.
For a drug offense within the prison, you mean?
Yes, and to get into the DDU, you don't need to participate in a prison riot. If you read the 103 CMR 430, it indicates the list of sanctions, and the list of sanctions is anywhere from participating in a prison riot to not making your bed. So I urge the court, because the CMR is in the list of what might constitute an infraction and what might cause you to be placed there can be fairly minor and completely at the discretion of the Department of Corrections.
Let's take a step back here. We don't have a maximum security prison for women in the Commonwealth, but women are convicted of first-degree murder. They go to Framingham.
That's correct.
Men go to the maximum security prison, Cedar Junction. Is that a problem as well? Do we need to, should we be building a maximum security prison for women so that there's equal treatment for equal
Well, what I'm asking this court to do is essentially, and if the Department of Corrections decides to either punish men differently in a certain way or confer a benefit upon men in a different way, or women for that matter.
Ms. Danielle has essentially conceded that. I mean, maybe the commissioner won't appreciate, but she said, don't talk to me about benefits. You can't give them benefits, I think.
But that is exactly what the ERA is designed to do. The ERA is designed to say, if the commissioner is not left unfettered to his own devices, he is still subject to the law of this Commonwealth. And the law of this Commonwealth is violations of gender discrimination are subject to strict scrutiny wherever they take place. And I'd ask this court to consider it's not just the Commonwealth who has examined this identical circumstance, gender discrimination in the prison context. All other states that follow the strict scrutiny application as we do in equal rights amendment cases that have exactly the same context as ours have largely applied.
All other states have largely applied? You mean some have applied and some haven't applied?
I apologize. Let me take that back. I apologize, Your Honor. They have applied. They've applied strict scrutiny in the prison context setting. And that's, I think, so important for the court to see that.
On the issue of punishment?
On
between genders, punishment between genders? Are other cases on punishment between genders?
Other cases of disparate treatment between men and women, where
in connection with punishment, prison management.
Right. For example, exactly in the question of whether or not there should be a maximum prison versus a minimum prison, that exact question was addressed, I think, in Mueller versus Gates in California.
In what?
Mueller versus Gates. It's cited in the amicus brief.
And what was the result?
The result was that strict scrutiny was applied, and that the efficiency of prison administration or the lowering costs would not be tolerated as a reason. That essentially strict scrutiny under that lens would not allow that a lesser would not tolerate the disparate treatment between the sexes.
Thank you, Ms. Jelishim.
Thank you. I just again ask the court to reaffirm the standard of strict scrutiny as it has in a line of unbroken cases since 1977.
We'll take a short break.
All rise.